Professor Carrington, welcome to Constitutional Chats. And please tell us a little bit about the Ninth Amendment, and then we're going to go to questions.
Wonderful. Kathy, thank you for having me again. I've been on a couple times, and so I'm somewhat surprised you're having me back, but thank you. No, I have enjoyed those opportunities, and I'm so thankful for the work that Constituting America does. It is I think, wonderful complement to what I try to do in the classroom, what many of my colleagues do here and are trying to do at other institutions and places across the country to really up the civic knowledge of we the people, and therefore help to have a more informed and then I think better governing citizenry. And so I've been asked today to talk about the Ninth Amendment, and the text, I'll just read it. It's only one sentence to get it into our minds before I have a few remarks on it. And it says that, quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." So in one sentence, there's a lot to consider. And I think one way to get at that is to first think of it in the history that it came out of. And it comes out, as the other amendments to the Bill of Rights did, from the ratification debate. But it has its own particular history within that ratification debate. The Anti-Federalists, those who were opposed to ratifying the Constitution, thought that either we should stick with the Articles of Confederation, amend it, or do something other than the proposed Constitution. One of their criticisms was that the original Constitution had just 7 articles and no Bill of Rights. There were bills of rights in state constitutions. There was a history of them. Something similar in English history, although they don't have a written constitution. And these bills of rights listed protections for persons against the government, made explicit, written out limitations the government had that individuals could claim as legal rights against government action. And the worry about the Anti-Federalists is if you don't have a Bill of Rights, the government will continue to expand, and that it will expand in running over the rights of the minority. It will prey on those who don't have enough votes to get themselves protected by a majority and by the laws. And that with our commitment to the rights of individuals in the United States that goes all the way back to before the founding, that would be a detrimental thing. It was not giving the government its proper limitations. Interestingly, the Federalists, those who supported the Constitution, saw a similar goal, the protection of rights, but thought that a Bill of Rights would have the opposite effect. And if you really want to get the best place to see this laid out, it's Federalist 84, which was written particularly by Alexander Hamilton, where he argues against a Bill of Rights for, among other reasons, that it would actually increase the power of the government against individuals. Now, that may be strange. How can you list limits to the government and somehow it's going to expand the government's power? He said it's going to be because it's going to switch the burden of proof, that our national government in particular is one of enumerated listed powers. You have to prove, if you're the government, that you can do something versus assume that you can. But if there's a list of things the government can't do, would that switch the burden of proof to the individual to prove that the government can't do it? In other words, would the government go from I can only do it if I can prove it to I can do it unless a Bill of Rights tells me I can't? And that actually would increase the power of the government in the very act that it was trying to limit it. And so what the Ninth Amendment really, I think, tried to do, what James Madison was trying to do with that, and he was one of the authors of the Federalist Papers, but also a somewhat skeptical of some of its powers afterward, it was an attempt to assuage both sides. It was part of a larger Bill of Rights that made the Anti-Federalists happier. I won't say maybe happy, but less unhappy maybe. But it also itself says that the burden of proof is supposed to remain on the government, that there are rights not listed that have to be followed by, that have to be respected by the United States government. And in the interpretation of these, the challenge is They were not speaking of listed constitutional rights. In fact, it explicitly is saying there are listed constitutional rights, namely the 8 amendments that precede it, certain parts of Article 1, Section 9 and 10, among others. So it acknowledges that enumerated or listed rights existed, but it says there are others, meaning by definition, they're not listed. They're not enumerated. Well, that begs the question, what are they? And not only what are they, what standard are we supposed to have? What content are we supposed to look to figure out what they are? How do you figure out something that's not there, or it's there but it's not there? One could say. And so so that becomes a challenge in American history for respecting this amendment, but also making sure it stays within its confines. And one thing you may ask is, well, why does this matter? Why do we care about getting this right beyond just wanting to be faithful to the Constitution? Well, you want to respect two perspectives that we have in our system of government. One is obviously the rights of individuals against others, especially the government. And if you don't get the content of the Ninth Amendment right, you could construe those rights too narrowly. You could not give protections that are supposed to be there for for individuals, and therefore undermine the purpose of government, which is to protect individual rights. At least that's a huge part of it. But on the other side, we also have the issue of the right of the people to govern themselves collectively through the law. It's not merely individuals against an amorphous, unnamed government. The government is supposed to itself be of, by, and for the people. So there needs to be adequate power for the people to act collectively through the law, right? So you have to have this balanced perspective of the individual against government, but also the government as itself a manifestation of the will of the people. And the worry on the other side is if you define the Ninth Amendment too broadly, you limit the right of the people to govern themselves legitimately through their representatives. And so there's been 4, and I'm just going to touch on them. I'm happy to get into these more as we have our discussion, but there's been 4 perspectives in modern times, really since the 1970s or 1980s, of how to put some meat and meaning on the Ninth Amendment. The first is to say that the rights granted in the Ninth Amendment, the content is those granted by the states, especially at the time of the ratification of the Constitution. So how do you know what are those rights that are retained? What were in the bills of rights of the states, what were protected by the states when ratification happened in 1791, and that's what remains. That was what they were trying to fix in stone. Others say that it is the collective right of the people to act, that you can't therefore pass a law denying the right of the people to abolish or amend the government, to undo the Article 5, the amendment process, or to even deny the right to revolution that the Declaration of Independence talks about. So the right to act collectively can't be taken away. The third is that everything not enumerated by the national government as a power is left to the people. In other words, it's just reinforcing the idea that the national government can only do what it's permitted to do, not do anything else. So as long as the national government can prove it has the power to do it, it's okay. Everything else would be a right retained by the people. And then finally, there's the idea that what this is talking about is what has often been called natural rights, that you have as a human being rights that precede government, that precede the laws, and that government and laws are instituted to protect. The Declaration of Independence talks in this language. To secure these unalienable rights, governments are instituted among men. And that really the task of the Ninth Amendment is figuring out what are the natural rights that attach to you, not as an American, not as a member of a state, not as a member of a club, but as a human being. And that's what those mean. All right. And so subsequently, there's been a lot of intellectual and scholarly debate about this. Not a lot of judicial debate, by the way. If you're in a con law class, you're not going to get a lot on the Ninth Amendment because it's just not been discussed much by the courts. But I would encourage that this is a good discussion to be having anyway, that we should not be limiting the importance of constitutional provisions by the mere fact of how much the courts debate them. that this is something that the American people need to ask, because it brings up essential questions that are much bigger than the Ninth Amendment itself. It really makes us fall back and ask, what is the role and purpose of government? And to ask how we see the individual, not just as a part of society, not just as a citizen, but also as a unique self, and what respect and dignity must attach to them in that context. And so I think we benefit from the discussion we can have about this. And therefore, I look forward to talking with the rest of you on the panel, and then other questions maybe from the audience if we have time, on how this can help us educate ourselves to be better citizens, better Americans, but also better human beings, and better adherence to the Constitution's powers, privileges, and limits. So thank you again for having me, and happy to have that discussion now.
Well, thank you. And that was a great explanation of the Ninth Amendment. And we actually asked a Twitter poll to promote this episode. And our question was, and we got this idea from you when we did our episode test, does the Ninth Amendment put the burden on the government or the people to justify claims against the other? And 48% of the Twitter poll answerers said the people, and 52% said the government. So, you know, 52% did get it correctly, that it puts the burden on the government, the Ninth Amendment does. But still, it shows, I think, how much people don't know about the Ninth Amendment. So we are just really appreciative of your time and all you do at Hillsdale. I remember when we were talking to someone before we had you for the first time, and we said, Professor Carrington's going to be on. They said, he's one of the most popular professors at Hillsdale. How did you get him? So anyway,
that's very kind.
We appreciate all that you do. So I'm going to, Tova, I'm going to turn it over to you.
Well, thank you so much. That was a really great breakdown. I liked how you went through like the 4 different interpretations. And I know you said that there hasn't been much literature from the courts about these interpretations, but I'm curious, of the cases that have been looked at by the courts, which of the 4 views does the court tend to side with?
Right. And I should even be more specific. There has never been a major holding of the Supreme Court where all 5 justices rested on the Ninth Amendment. So even when it's been asserted by the court, or it's usually been by a particular justice, as opposed to in general. So some of the bigger ones, I'll just mention them. I know these are some pretty hot button ones. So if people are interested, they could maybe look them up themselves. But there was a one opinion in a case called Griswold versus Connecticut, where one of the concurring opinions about, it was a privacy case, where asserted that the Ninth Amendment as the place for the unenumerated right that was being asserted there. A lower court in Roe v. Wade, which obviously is a pretty big and controversial case, the lower district court had asserted the Ninth Amendment as the basis for what it was discussing, for what Roe v. Wade was about. The majority opinion refused to acknowledge or deny that that was the best basis. They just mentioned in passing that it had been made. So while those are pretty big cases, in neither of them was the Ninth Amendment rested on as the ground. They actually turned to other things like the 14th Amendment or the Fifth Amendment or the Fourth Amendment. So that's partly why it hasn't come up. In fact, there was a man that was up for the Supreme Court named Robert Bork, who ended up getting not appointed to the Supreme Court in the 1980s. He got voted down. And he was debating about the meaning of the Ninth Amendment and called it the equivalent of an ink blot, meaning that if you see something with an ink blot on it, you have trouble discerning what's actually in it, and that he made a similar argument about the content of the Ninth Amendment. And judges have been reticent to really lean on it because they're aware that they need to have some limits on their own interpretation. And the fact that the Ninth Amendment is so general in its statement, and that there hasn't been a 100% agreed upon content list to it, has made them reticent to really lean hard on it rather than just mention it offhand.
And with these interpretations, I guess from like legal scholars, has the understanding of it changed throughout time, or has it sort of, there've always been these four tracks?
Right. I think that the opinion that well, in some ways the opinions could interlock, or at least some of them. If you look back at, say, James Madison, who's putting the amendment forward, he and those of his generation certainly were coming at the role and purpose of government from something like the fourth option about human beings have inherent human or natural rights, and that the Declaration of Independence, which Madison's good friend Thomas Jefferson had been the primary author. I mean, it was edited by the Continental Congress. Certainly agreed with this idea of these inherent rights that government doesn't create, society doesn't bestow, but occur just because you're a human being. But I think some of the idea was that the other interpretations, the idea that the people have the right to alter or abolish the government, was meant to be as a way of protecting those rights, or that rights granted by the states at the time were drawing from that original view. But I think you get actually greater division when you get into the 20th and 21st century, because that common foundation about what rights are and where they come from, while it was never perfectly aligned, becomes less uniform. And you start to get more parts of society that say that none of our rights are natural. They all come from society or the development of history, or from just the law itself. You get others who have a more expansive view of where rights come from, other than the older natural rights view. And so I think you start to see a division of these views in the 1970s and 80s, partly because they're reacting to less unity among the American people on the underlying first principles, you could say, of justice and good and the purpose of government. And that's where you could possibly put these all together in a certain way. That becomes harder as time goes on.
Right. That's a really good point, that like, as people become more polarized, or ideas of like what our inherent rights are different, sometimes these definitions that seem to be inherent are not as self-evident anymore. So that's a really interesting point. And then we've talked with some other amendments about like incorporation to the states. Is that something that is even like possible with the Ninth Amendment? Or, obviously if there haven't been cases about it, I'm sure it hasn't been, but has there ever been an effort to do that?
It has not been incorporated, in part because one would have to, 5 justices would have to have agreed that it was the basis for their decision. But it would be interesting, because it merely talks about the rights in the Constitution. So it could be incorporated, and I would argue that at least a comparable philosophy of it has been incorporated, but not through the Ninth Amendment itself. And where I think it probably has been is the idea that in incorporating most of the first of 8 amendments through the 14th, there has been a articulation that things like the word liberty in the 14th Amendment includes more than just the listed rights of the Bill of Rights. It includes unenumerated rights. And because of that, I think that the idea has been, even though the Ninth Amendment itself has not been incorporated, the idea that the protections the Constitution affords go beyond just what is literally listed and concretely laid out has been. But the court has chosen to do that through words like liberty in the 14th Amendment, liberty even in the due process clause of the 5th Amendment, rather than the 9th Amendment directly.
Yeah, thank you. And I guess if you could speak, this is just such an interesting train of thought about like how the law defines these more abstract, concepts. So like, could you just speak more broadly about how like a court would go about defining a term like liberty or equality or freedom, or like, the pursuit of happiness? Like what does that rest on? Is that supposed to be based off of the founder? I mean, obviously I know these are like bigger debates in legal theory, but some people think it should be based on like what the actual founders thought. Some people think maybe it's rooted in like a deeper tradition in Western thought. Some people say maybe it's something broader, or should be based on our modern values. Could you like take us through how that process works in courts?
Right. And there are disagreements on that manifest themselves in on the current court. And I'll say first what's at stake in that debate, because I think it matters to know what's at stake in order to then know how important the particular viewpoints are, or who's right in the particular viewpoints are more right. And what's really underneath that is the question of the rule of law. We have dedicated ourselves as a country to the idea that we don't manipulate words to do what we want. We follow words that are put into law through the regular process so that we hold ourselves accountable and that we have objective standards to claim justice by. And so therefore, if we can't read a text, that severely undermines our ability to have that rule of law, and severely and puts in the danger of the words merely being manipulated for our own particular purposes. Now, that said, in order to get at that, obviously the place you need to start, I think almost anyone would say, is with the words themselves. And there are questions the words themselves answer. So, for example, in the Ninth Amendment, you can't look in the Ninth Amendment for the protection of a right that's already enumerated. It does make that distinction that if it's listed in the Constitution, that's not the source for it. It does give some idea of what its content could be, I think, in the idea of denying and disparaging. I think we could talk more about that if people are interested. At the same time, how do you get the idea? Now, you've talked a little bit about what some people call originalism. And what that argues is that there should be a preference to finding in some ways what the people who passed that amendment or passed whatever law we're looking at thought at the time it was passed. Now, why is that the case? Is it necessarily because we think they're better than us or they're more brilliant? Well, not necessarily, although a lot of people do think that. It's really just saying the intention of those who made the law is important because their will was what was being put into law. And therefore, it should be respected until we, the people, exercise a new will or a different will to change it again, which then itself should have a similar respect. And so how do you get at that? And one way that you can get at that is looking at the history and tradition at the time. What was the commonly understood meaning of the words? What did people say and write about it? What did they do at the time to make sure that's the case? Now, pushing back against that is the idea that the Constitution, while occurring and while being passed at a particular time and place, was meant to last generations, centuries, maybe even, as close to forever as the founders could get it. And so there's going to need to be some contextualization of it. So where do you go from this is the principle of that text that doesn't change, and the text in history and the tradition must bind it to that time? And to what degree does it need to be contextualized to time and place now? And one way that debate goes on is through things like technology. We have a right to no illegal searches and seizures. And that's pretty clear that invading the home without a warrant is not allowed by the government. On the other hand, what do you do with wiretapping when the founders had no idea what a phone was, right? And so that's where the kind of idea of evolution happens. And to what degree does it need to be contextualized? And then there's a third group that says the Constitution needs to be, and I'll stop here because I know I've been going for a bit, but where the Constitution needs to evolve intrinsically to fit the values of today. The issue with that is, where does the evolution stop when you do already have an amendment process? And so really it's back to, if anyone's been in a philosophy class, the idea that some things change and some things stay the same. And the question of constitutional interpretation is where to draw the line between those two things. And again, at stake is, how do we respect the text for how it was originally intended, but how do we marry that to seeing the text as something that has a life and application beyond the generation that made it?
Well, thank you so much. You gave very specific, great answers to my broad general questions. So I appreciate it. And now I will pass on to Jewel and Jordan.
All right, thank you for the discussion so far. First of all, you had mentioned Alexander Hamilton when you were discussing how this amendment came about and his critique of it actually doing the opposite of what we would think it would do. Alexander Hamilton is often, who of course was popularized in the musical that came out, Hamilton, but in a broader sense, not a broader sense, in a particular sense in education, he's often referred to as being super pro central government, very put it almost into the side of you could, like a tyrannical type of a sense that he would have even been for, and used in some classes I've been in, even to say that all of our founding fathers did not agree with blah, 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 like basically setting him against what we would think of as the founding father principles. So for him to then be arguing that this amendment would then take away freedom or right from the people, because it would make it seem as if the people had to, that it would make it seem as if the things that, not this amendment, if you had a Bill of Rights, but the Bill of Rights would make it seem as if it was not listed, the people didn't have that right, would seemingly contradict the way that he's often phrased in academic circles, probably not quite at Hillsdale, but in other places. So could you maybe just comment on that first, of that, were the founding fathers who were more towards Hamilton's side, or where in Hamilton's writings do we see his concern with individual rights to where he would have that position? Or are we to think that that position was just politically expedient?
Right. A good question, and shows, and I think that the broader question there is, what was the consensus among the framers or the founding fathers, and where did they differ? How did they all join in the American Revolution and then split and fight like cats and dogs in the 1790s between the Federalists and the Democratic Republicans, the Hamiltonians and the Jeffersonians? And I think I don't think that Hamilton's argument in Federalist 84 is purely political in the sense of trying to score points, and it's not what he actually believed. And one thing I would point to is there's the song in the musical you mentioned called "The Farmer Refuted." Well, that is based off a document that he wrote, an exchange he had. And if you look at the arguments, this doesn't really come up in the song, but if you go and read that document, which Tova, I think Kathy said that you're 19 years old. He wrote this when he was 19. So he actually lays out his view of the purposes of government. And that view is basically indistinguishable from Thomas Jefferson, his later archenemy's view as expressed in the Declaration of Independence. He says human beings have natural rights that come from God. They're endowed to them in the act of their being born, that those rights are life, liberty, and property, although he also talks about happiness and its pursuit, and that governments are instituted to protect those rights, and that whenever government ever violates those rights, whenever it goes beyond that, it has gone beyond its purpose and needs to be altered or abolished. And so on that, the founders, I don't think, disagreed. They were united on that. When you get past the passing of the vindication of the Declaration of Independence, though, you get a disagreement on two things. One is federalism. So which level of government, national or state, should be acting in a certain situation to do the legitimate things that government are allowed to do? And it's interesting, Hamilton, while he certainly wanted the national government to do more than Jefferson, he actually was more critical of the state governments, that they were infringing on individual rights, and thought a stronger national government would actually protect individual liberty because it would rein in the states themselves. So Jefferson sometimes is presented almost libertarian like, well, he wanted a smaller federal government, but he wanted a pretty powerful state government that Hamilton wanted to limit. So on that, it was more of a matter of states versus national government. The other, though, is Hamilton also said, if the goal is to protect rights, a thing we can't lose sight of is that government is not the only threat to rights. That if that was the case, we should just have anarchy. That would be the answer. The fact is, we have government because other individuals or other groups are a threat to rights. It's other individuals that could break into your home, that could try to kill you, that could steal your things, that could hurt your property, that could slander your name, other things like that. And so government actually needs to be in place to protect you against those threats. And if that's the case, if you don't have a government with enough power, then you're not safe. Just as if you have a government that's too powerful, you're not safe. And so the founders in the 1790s and beyond, they certainly disagreed on where was the perfect place to draw that line between a government that is strong enough to protect your rights, but not so strong that it's a threat to your rights. But that disagreement was not one of fundamental principle. It was a disagreement of degree and what was the wisest necessity for the society at the time. And so I think that's sort of the answer there. Where did Hamilton want a bigger government than Jefferson at the national level? Yes. That doesn't mean he wanted a bigger government necessarily overall, although I still think that's true. But that bigger government is for a very limited purpose compared to, I think, what some might say today. And it was still for the protection of individual rights.
Thanks for that full answer. I think it's important the way that you laid that out so clearly, and that you pointed us to a document where we could read it for ourselves, part of his idea for what government should be. And also because today, partially because of the musical, but also because it's one of the founders that you could point to, it seems as if we're getting a different view of who Hamilton probably was in classrooms all over America. And it is really hard to make that delineation you did, which is that, yes, we do have two different views of government, but both views are for the purpose of protecting the maximum amount of rights.
Yeah, and one thing I might just say, interject on that, is the great importance, I think, in and out of the classroom of primary documents. And I never like to just tell my students, this is what so-and-so thought or did. I like to show them by giving them, what did Hamilton actually write? What did Jefferson actually write? What did Benjamin Franklin or Abraham Lincoln or Aristotle? Because I say, don't just take my word for it. See if that's what you think they really were saying. And I think that's a huge line between maybe education and indoctrination, is to educate so that you can think for yourself, so that you can approach those documents for yourself. So yeah, I would encourage people, go read what they wrote, and come and send me an email telling me why I'm wrong if I didn't read them right. I think that's a huge part of what education can and should be. So sorry, I didn't mean to jump on that, but
no, go ahead.
Yeah,
someone please take them up on that. That would be fun. So then getting to this amendment, part of what I'm wondering is that we talked about how the 14th Amendment really changed the relationship of the Bill of Rights to the people, because we learned that the Bill of Rights was about what the federal government could not do to the people. And it wasn't until later that we applied that to also the state governments. Do you think that part of why there was not earlier any judicial precedence on this amendment is because it was not applied to what the state governments could do?
Yeah, that's a good question. I think with that, you have to go to the Supreme Court case of Barron v. Baltimore. I don't know if that's come up in your previous discussions. Barron v. Baltimore, written in 1833 by Chief Justice John Marshall, the greatest Chief Justice to sit on the Supreme Court. And I mean greatest, many of us think he's the greatest in quality, but he certainly was the greatest in power. I think that's pretty undebatable. And he wrote that opinion. He was also a founder. He basically argued that, why is it that the Bill of Rights only applies to the national government? And he said the reason it does is you have a people that create a government through a constitution. That is a general process. And you have, in this case, the American people that create the national government through its own constitution. that's not the only people within the United States. There's the people of the state of Michigan, where I live. There's the people of the state of Pennsylvania. There's the state of other states. They also have governments that are created through their own constitutions, which themselves, by the way, have bills of rights, etc. And so the idea is the Constitution should only apply to the government that it was supposed to apply to. And the understanding was, while there are limits in the United States Constitution on the states prior to the 14th Amendment, those are specified specifically that they're limitations on the states. And when they're not listed against the states, the assumption is they're against the government that they are against the government that Constitution was used to create and maintain, in this case, the United States Constitution. So that kind of logic of the relationship of a people, a constitution, and a government is the main reason that came up. And then it's only with the 14th Amendment and the added restrictions that it placed on the state governments that the question of the application of the Bill of Rights became a new debated topic again. So by the way, that doesn't mean that there aren't protections of rights against the state governments. It's that that's the role of that people of that state, and it's the role of them in constructing and amending their state constitution to make that happen.
Yeah, so then that kind of leads into the next question, which is if you could comment on this idea, pretty much, is that when we see an amendment like this written out, I think it flies directly against this concept that that has slipped into our common speech, which is using the word democracy almost as a parallel to good and freedom, like as if it's democracy is always good and democracy is always free. But if the majority of the people decide to vote to take away the rights from the minority, that would also be a democracy. So in an amendment like this specifically relates to that. We don't deify democracy, but in common discourse, the word democracy is particularly used as if it is the end all be all of what is good government. Do you think that education on this amendment particularly would help break that concept?
I think so, because again, as I was saying in my opening remarks, I think it throws us back on those kind of first principles to which you were alluding. And two historical discussions that I would point people to. One is Federalist 9, which was also written by Hamilton, but I think Madison completely agrees with this in, say, Federalist 51 or Federalist 10. And it's the idea that the history of republics or popular governments, of which democracy is a subset, had not historically been very good. They had tended to end in tyranny or anarchy for this very reason, that the majority had, just like a rule of one king or the rule of a few elite aristocrats, even the rule of the many has flaws, because human beings have flaws. Men are not angels, as Federalist 51 says. And Federalist 9 basically says the history of republics is so bad because of the idea of this majority tyranny, a majority ganging up on a minority, that if we can't do a better job than ancient republics did, we basically should give up on popular government. And they say, and Hamilton there says, thankfully, the science of politics has improved. Our Constitution has figured out a way to do republics better, to be more moderate, to be more, in that case, rights affirming. And therefore, that's the case. And I think one way to look at it, and this comes up in the Lincoln-Douglas debates, fast forward into the 1858, is that you have to ask, what's the relationship between democracy and individual rights? And some would say that individual rights are created by the majority. Well, if that's the case, they can be uncreated or taken away. And that's kind of what Stephen Douglas said in the Lincoln-Douglas debates when he said, I've got the fix for slavery. Let's just vote on it. We can vote on it, and even vote on it locally. And by doing so and voting on it locally, we'll solve the issue. Aren't we a democracy, right? As you said. Lincoln comes back and says, you've got your ordering wrong, because the other option is to say that democracy is a necessary result of individual rights, that we have the right to life, liberty, and property, that those are natural, and that no one else, therefore, and that we have them equally. And because we have them equally, no one else can rule us except by our consent. How do you get rule among equals? Consent. But that rule must only come out of the idea that we have these rights. So democracy is a result of rights, but that means democracy is limited by, in its actions, by respecting the rights that gave birth to it. And that's what Lincoln says about slavery. Lincoln says you can't vote on slavery as if it's voting on, do I want chocolate or vanilla ice cream? Because what's the very reason you can vote? The very reason you can vote is because you need consent. The very reason that you need consent is the idea that all men are created equal. So you're going to vote to approve of slavery, which is a declaration that all men are not equal, in order to affirm, are you going to exercise your equality to deny equality? And so I think the ultimate wisdom of the framers and the founders is to say that governments are actually instituted to pursue justice, and that consent to the governed and rule of the majority is a manifestation of that, but also is therefore limited by that goal. And putting them together is the task of, I think, adhering to both the Constitution and the Declaration of Independence, to say, how do we wisely put those two things together so that we respect the people's right to rule and respect the individual rights that the people are supposed to pursue in making that rule actual.
So earlier you had spoken of the 4 prisms that you can view this amendment through. And I'm curious, do you believe that you need all 4 to get the full breadth of the amendment? Or is there a mix of a couple that you would use to view it, or one particularly that you think you can, that you use when you're talking about this amendment?
Yeah, and certainly in the classroom, I tried to be as fair as I can when I lay out these views, and respect when students come to a different conclusion, because I could name you a thoughtful scholar behind each one of these views. I think that there is a way to put them together, and I kind of alluded to that earlier, and it would be one that I find fairly convincing. Although, again, I have people I very much respect that would disagree with me, but it would need to start with, I think, the last of the 4 views, the idea that the Constitution is picking up on the idea of rights of human beings that precede government and the government exists to protect. And I think you could put that with the idea that it's a collective right of the people to alter and abolish government, because that, to protect the other rights, the Declaration says you have that right. It wouldn't be perfectly overlapping with the idea that these are rights granted by the states. But if you look at most state constitutions at the time of ratification, they themselves were saying the rights we're protecting come out of this view of human beings. And then the idea that everything not enumerated is as a power of the federal government is what's retained would probably be more expansive than the idea of your natural rights, but would certainly include them. So I think what you could find from this is that idea of natural rights being the core, but the other amendments being ways of at least cabining in, clarifying, or supporting. Whereas I don't think that you could maybe put them perfectly together. I think you'd have to commit to one as the starting point and then bring in the others as they complement, reinforce, or help. And I think that's why you still have some disagreement among the scholars, even when I like I said, I think there might be a way to at least get them to complement to some degree.
Thank you. And this amendment is so, as you said, it's so broadly written. Why do you think it's so broad? Do you think it was necessary? Do you think it was necessary for it to be broad? Or was it more of that there's kind of a different understanding when it was written? And it, when it was written, it wasn't written so broadly because of their different understandings.
Mm-hmm. Yeah, I don't think it was written necessarily because of broad disagreement over the nature or content of the rights. I think it was written broadly because of what it was trying to avoid, which was the Federalist 84 worry about if you tried to list out more rights, then the problem is it would keep that standard as it would continue to risk putting the standard or the onus on the individual to prove the government can't do it rather than on the government to prove it can. So by not enumerating them, it was trying to mitigate that complaint from Federalist 84. And I think the argument there is, if you really do believe that everything the government is not given the power to do, especially the national government, results in rights retained by the people, how could you list them all out? You know, do I have a right to blink? Do I have a right to wear these headphones? Do you have a right to wear a hoodie, right? What color hoodie, right? And I don't mean to be trite about this, but actually there was a less well-known founder, I'm blanking on his name now. He was a high Federalist from Massachusetts, and I apologize, I can't remember his name right now. Who really pushed this and said, "Do I have a right to skip, jump, wear a hat, not wear a hat?" And so I think the idea was this was meant to establish a broader principle and burden of proof, and that would result in a much more substantive, effective, and more blanket protection of the rights that they were trying to maintain, and not by unintentional consequences let slip in the very problem they were trying to guard against by adding this amendment onto the enumerated rights that were listed in the first 8.
Thank you. Answers perfectly. Sometimes I just like to have the guests connect all the dots for me to make sure I'm on the right path.
Yeah.
I think it's time for some audience questions, though, and I think we have some great ones.
Definitely. And thank you, Jewel and Jorn, and thank you, Tova, for all your great questions. And at this time in the show, we also like to always recognize our students that we know are watching today. And we have some students with Francisca Amato Banfield who are watching. And last week, we didn't get to recognize Cami Wainhouse's students, Thea Alphas's students, and then Deb Hansen had 33 students on from Janesville Elementary. So we want to welcome all of our students and teachers who are in the audience. And if we didn't call out your name and you want to type your name with your students in the chat, we'll be sure and get you recognized as well. So Professor Carrington, Sandy Thatcher asks, why does the 10th Amendment refer to the states as well as the people, while the 9th Amendment refers just to the people? What rights and powers do the people have against the states?
Right. I think that the reason that the 10th Amendment mentions the people and the state, it's meant to be a complement to the 9th Amendment. And I think that it's in some ways meant to reinforce the 9th Amendment itself. So what the 10th Amendment is saying is everything not given to the national government is left somewhere else. But what it's recognizing is that somewhere else could be with the state governments, but doesn't have to be. It could be either something that the states should be doing instead of the national government, but it could be something that no government should be doing. It should just be retained by the people directly as their rights. And so it is laying out that even in the 10th Amendment, don't read the 10th Amendment in competition with the 9th as saying, well, actually government can do anything. It's just a matter of whether it's the national or the state government. It says there are rights retained by the people themselves. That's really just, I think, building off of what 9 itself was saying. So while 9 is directly focused on the rights of individuals vis-a-vis the national government, the 10th is saying we're not contradicting that. We're saying even in federalism, some things are national, some things are state. The rest are going to be left to the people as well. So that's how I think I think it's being careful in trying to not get people to pit the amendments against each other, but to see them as complementing.
Interesting. And then Bill Carey goes back to something we talked about a little bit earlier in the show. He asks, why do we think the courts avoid relying on the 9th? There is little in the Constitution that has not been litigated. Why not the 9th?
Yeah, I think that that's a very good question. And I think it's because of the judge's reticence to make a determination about what the content of the amendment would be. And this is where the judges do recognize they're unelected. They are supposed to put the will of the people into place. And they like to go with, generally, there's some exceptions on the courts, but they like to go with something that's more specific, something that's clearer, something that's more particular. And even the word liberty, as capacious as it is in the 14th Amendment, is at least more specific. And so I think that that's the reason, one of the reasons they've been very reticent to do so, where they've been able to find a more specific text, a more specific issue, way of dealing with a legal claim. They've wanted to go with that because they don't want to generally be seen as reading their own views in. And even though they're obviously often accused of doing so, this amendment is one of the harder ones to come to a conclusion about what the particular content is. And I think that's why they partly wanted to avoid it. At the same time, there's good judicial scholars that have said that's a travesty, because if it's a part of the Constitution, it needs to have some meaning that is enforceable. And so in some ways, by not doing so, we've undermined our ability to come to that conclusion through the kind of discussion, debate, and adjudication that we've been able to do with other provisions.
Very interesting. Michael Takak has a statement. I'm wondering if you want to make any comments on that. Michael says, relative to natural rights, there is one-to-one mapping to the physical constructal law. Have you ever thought about that before? Natural rights, I guess, versus maybe the laws of physics, or is that?
Let me take a stab at that, having only done mediocre in my physics class in high school. I mean, it's interesting. What do you mean by a natural law? And there are natural laws that state sort of, you could say, non-moral facts about the nature of a heartbeat, or osmosis, or photosynthesis, or things like that. And what the laws of nature and nature's God that the Declaration talks about, or natural rights is supposed to talk about, is not merely what we do, it's the obligation that we morally have to each other. They're facts in a moral sense. And so it's not arguing, and Hamilton says this in The Farmer Refuted, it's not claiming that everyone follows them, because men aren't angels, as his colleague Madison would say in Federalist 51, but that naturally, as what we are as human beings, apart from convention, apart from tradition, just what it means to be human means that there are moral obligations we have to each other as far as what we should respect about human dignity, what we should respect about rights. And that's what at least the founders were talking about when they spoke in that language. So are they true? Yes, but they're not true in the sense of mechanical kind of determinism. They're true in the sense of the moral obligations that we as free but flawed human beings are supposed to follow.
I think that's a great answer. And then Dr. Braverman asks a very interesting question. Do you think that the Constitution would have been ratified if the Bill of Rights was attached on September 17th, 1787?
I think without the promise of the Bill of Rights, I don't think it would have been. You had some very close votes in some of the states that were very essential to passage. And I think that the promise among some of the moderates, between the very staunchly pro-Constitution and very staunchly anti-Federalist parties, the middle ground, really, it was a compromise that was needed to get the Constitution passed. And there's certainly debate as to how well it served us. I think there's a lot of evidence that the anti-federalists were right on that it was necessary. But I think as a purely political matter, no. Would it have passed in some states? Yes, but I think it tipped it over in some of the very closer states that this was a compromise that needed to be made to get it passed. And then we can, ask the question of how good or bad. The Constitution seems to have worked pretty well, so I don't want to disparage it. But as far as just the political, yes, I think it was necessary. I don't think it would have been passed in enough states otherwise. Certainly not unanimously.
Well, thank you. And we are right at the top of the hour. So we want to thank you so much. We really appreciate your time during a very busy week for a university professor. So thank you so much for being with us. And thank you for all that Hillsdale does. We at Constituting America love Hillsdale and just think so highly of your work. And I'm going to, Jewel and Jorn, is there anything y'all would like to say in closing?
Just thank you very much for a great show. You really, you really expanded our knowledge of the Ninth Amendment.
Oh, well, thank you very much. It was an honor to be on, and thank you all for your very good work. Happy to be whatever part I can be of it.
Well, thank you. We want to thank our audience for being with us today and come back next week. We're going to be talking about the 10th Amendment with Dr. Jeff Skakanga of the Ashbrook Center and wrapping up our series on Bill of Rights. And look forward to seeing everybody next week. So thank you.